In the previous video, we discussed Article 188. In this video, let us discuss Article 189. The pith and substance of this article is that any issue in the state legislatures shall be decided by a majority vote. The Speaker of the Assembly and the Chairman of the Council do not have voting right in the first instance. However, when a matter has become a tie that both sides are equal, then the Speaker and the Chairman will have a casting vote. The state legislatures can act irrespective of the vacancies in the legislatures. The vacancies might have arisen due to death, resignation, or disqualification of members. In spite of there being some seats vacant, the legislatures can carry on their business, and the proceedings will not be held invalid only because some member who is not entitled to sit in the legislatures and vote has sit in the legislatures or voted in the proceedings. That will not vitiate the proceedings. The proceedings will be valid. Clause 3 about the quorum of the legislatures. The quorum is said to be 10 members or 10% of the total membership of the legislatures, irrespective of the vacancies. However, the Parliament has power to amend this provision. Clause 4 says that if there is no quorum for any meeting, it shall be the responsibility of the Speaker or the Chairman, as the case may be, to adjourn the House or to suspend the meeting until there is a quorum. Let us make some relevant discussions on this. What is the significance of this quorum? Either 10 members or 10% of the total membership of the House. By this, we can understand that the intention of the Constitution could be that each state may be having around 100 seats in its assembly. We know minimum number in the council shall be 40, and it shall be at least 1/3 of the membership of the assembly. In that case, it appears the total membership of a legislative assembly should be at least 120 to get a legislative council. But when the quorum is said to be 10 members or 10%, we may assume that membership in a legislative assembly could have been visualized by the members of the Constituent Assembly to be between 100 and 120 or around that. We know, I told you several times, the scheme of the Constitution is such that census should be taken every 10 years and the state should be reorganized every 10 years. And the seats of MLAs and MPs also should be readjusted every 10 years. That is the scheme of the Constitution. Census were first conducted in 1951 and first elections were conducted in 1952 based on those census. Thereafter, every 10 years census are being carried out, but states are not being reorganized and the seats in the legislatures are not being readjusted. It is a constitutional misunderstanding. It goes to the root of democracy. As a result of migrations from one state to the other and migrations from India to other countries, as a result of which some assembly constituencies are having 40 to 50,000 voters, while some assembly constituencies are having nearly 10 lakh voters. The same way, some parliament constituencies are having 2 to 2.5 lakh voters, and some parliament constituencies are having 20 lakh voters or even 25 lakh voters. Some states are having population of less than 1 crore, and some states like Uttar Pradesh are having population of 20 crores. This is not contemplated by the Constitution. Article 55 says that each state shall have equal scale of representation in electing the President of India. Article 81 and 170 says that the population represented by each MP and the population represented by each MLA respectively should be, as far as practicable, shall be equal. It means that in terms of Article 55, 81 and 170, each state should have equal number of population, equal number of MLAs and equal number of parliament members, and the people represented by each of them shall be, as far as practicable, equal throughout the country. To facilitate this kind of reorganization of states every 10 years based on the census, Article 3 and 4 are embedded into the Constitution. Article 3 says that the Parliament has power to divide the countries, unite the countries, change the boundaries, extent and status of the states and their names. And Article 4 says that such an action shall not be treated as a constitutional amendment. This is done especially to facilitate easy reorganization of states and readjustments of legislative seats. This constitutional concept, Indian polity, press, judiciary and intelligentsia have failed to understand. This is a serious lapse. We have nullified the executive by saying that he should assent to whatever bill sent by the legislative leader. That means there is no effective executive. Thus, there is no separation of powers between the legislative, executive and the judiciary. Judiciary interferes with the legislative proceedings. Legislative leader subdues or rights the executive. Thus, in total, the Indians made mess of democracy. Let us also consider Article 164. It says that the number of ministers in a state shall be a minimum of 12 and a maximum of 15% of the total membership of the Legislative Assembly. If 15% is 12, so 100% would be around 90. That means it appears to me that the Constitution envisioned the states to be having between 100 and 120 MLA seats. Against that, we have divided the country into unequal states, linguistic states. Later, states were divided on political considerations. UP has 400 MLA seats and some states have, like Sikkim, have 32 MLA seats. This is a great injustice. Smaller states get neglected by the union government. They do not get their due share in electing the ruler of this country, who is President of India. President of India is the only elected executive in India. Prime Minister and Chief Minister are not elected people. They could be members of the councils, and as ministers they are appointed and they hold office during the pleasure of the executive under Article 75 and 164. Somebody becoming Chief Minister with majority in the Assembly and some other becoming Prime Minister with majority in the Parliament are contained in Article 91 and 130 of the Pakistan Constitution, but such provisions are not there under Indian Constitution. Pakistan has adapted almost similar provisions from Indian Constitution. For example, the term of Prime Minister shall be during the pleasure of the President. This is what is contained in Article 75 in Indian Constitution. Under Article 95 of the Pakistan Constitution, they added that the term of minister shall be during the pleasure of the President. Verbatim the same with Indian Constitution. As a suffix they added that, however, the President shall not exercise his option without conducting a no confidence motion on the floor of the Parliament. Such a suffix is not there in India, but yet we are following the same procedure as is being followed in Pakistan. However, coming back, quorum, we discussed that will be either 10 members or 10% of the membership of the Legislative Assembly. Let us say the party of the President at the union level and in states, it is the party represented by the governor. Necessarily, President and governors are political people. They are representatives of political party. They represent one section of the legislatures, executive, and other parties, sometimes who may be in majority in the legislatures, is another section of the legislatures. Supposing the party of the governor, namely the party of the President, does not have 10 members or 10% of the membership of the House, whichever is more, he does not have such membership. Then what should happen? Supposing, let us take the example of a state having 100 assembly seats. So it should have at least 10 members to make a quorum to meet. But the party of the governor is having only 5 members. Of course, he can appoint members who are from the Legislative Council and even altogether new people also governor can appoint as ministers under Article 164. Supposing there are only 5 people members, ministers are not members, they are not entitled to vote. They can attend and speak, and the Advocate General can attend and speak, but they are not members, and by dint of this Article 164 alone, and they are not entitled to vote unless they are members of that house. Whereas in the assembly, let us assume governor has only 5 members. Then what should happen? The opposition parties usually would cooperate in making the laws for the country, but predominantly whichever are agreeable to them, and of course to the executive as well, because executive has to assent to the bills. If he does not assent to bill, the majority party leader in the assembly will go to the masses and explain to them that the governor is not assenting to a beneficial bill. On the contrary, the governor and his ministers should go to the masses and explain why he has withheld the bill or rejected the bill or sent for consideration of the President of India. Ultimately, it is the people who decide whether the majority party in the assembly which passed a bill is right or the governor is right in assenting to it, withholding it, returning it, or sending it for consideration of the President under Article 201. It is the people who will decide in the next ensuing general elections. That is the beauty of democracy. Judiciary is not supposed to interfere with this democracy and right of the treasury benches, right of the opposition parties, and right of the people to judge over the actions of the legislatures and the executive. If you remember, under Article 356, state assemblies and state government both are dissolved by the President of India under certain circumstances. The circumstance is that either based on the report of the governor or otherwise, if the president feels that the administration of the state cannot be run in accordance with the provisions of the constitution, he shall make a declaration to the effect that the assembly, the legislatures, and the government are dissolved. The duties of the assemblies are taken over by the parliament, and the duties of the governor, namely the government, are taken over by the president or his assigns. This kind of situation which is envisaged under Article 356. Unfortunately, we have witnessed on several occasions when Article 356 was used for law and order situations in the states. To tackle law and order situations, there is Article 355, whereby the central government can send central forces and suppress such movements and bring the state into order. The assembly or the government are not dissolved, but whereas under Article 356, it is not the law and order situations, but other situations where the administration of the state cannot be run in accordance with the provisions of the constitution. This Indians have not understood properly. And the dissolution under Article 356 is only temporary. It is a suspension because it is conditioned that Article 356 declaration cannot go beyond 1 year. That means when you have decided a deadline of 1 year, we must understand that it is a suspension. If it is a dismissal, there is no question of again declaring any deadline. So we have studied today the voting rules in state legislatures. Thank you. Thank you for watching my videos on the Constitution. I request you to please subscribe, share and comment on my videos so that the constitutional message, the true message, is spread wider and faster into Indian citizens, and I hope it would bring sooner or later the social, political, economic changes in the country for the good of the country. I am going to discuss each and every article of this constitution, highlighting wherever they went wrong. They were misused, misapplied or misunderstood. Thank you. Thank you for watching this video.